Good afternoon and welcome to the Appellate Division First Department. Before we start, I want to welcome several visitors. You see we have a lot of visitors on the flanks here. All either aspiring law students or just on the cusp of becoming one. So I want to welcome the Latino Judges Association's interns this afternoon. We are so happy to have you here. And I also want to welcome the 30 wonderful students from the New York Leo program who are over here on the right. And they are all about to start law school. And as I told them before we began, I hope nothing they see today discourages them from their law pursuits. But I also hope that you notice that this afternoon, we have for the first time, well, for the second time, in the 131-year history of this court, since its birth, an all-Latino bench. It's only the second time that that has happened in the 131 years that this court has been in existence. I am so very happy and proud to be the jurist presiding this time, as the first time that this occurred, it was our former PJ, Rolando Acosta, and so he sat in the middle. So Rolando, thank you. But I share that with you because I think it's important in today's climate that we celebrate diversity. It is not a dirty word. It is what has elevated this country and made it truly great. That being said, let's go with the call of the calendar. You all know my shtick. Please ask for the time that you need, not the time that you want. Understanding I have over 5 hours of requested argument time. So please know that we are familiar with your case, with the record, the briefs, usually more than you wish we were. So know that the time that I give you is a time clock for you, not for my colleagues, so that if you are brilliant and they have more questions, I let the clock go. All right? That being said, People versus Kejan Yazar. Okay. All right, let's do 5 and 1 and 5. And like I said, you'll probably go into 6 anyway. All right. Badesh versus Fort 710 Associates. Okay, respondent? Looks like you scared them away. So let's modify that time. How much time do you need to get your argument out? 5 minutes. Okay, let's try 4 and see, since you have no one you're arguing against, okay? All right. S. Jodicy versus Sheila M.
Good morning.
Good morning.
Attorney for the child.
Okay, you see it's just us, so I'm gonna give you 2 minutes and you let me know what we need to know, okay? Zang versus Chu, there are 2 cases, we're hearing them together, so we're not getting 2 separate times, gentlemen. Give me your time request. 10 minutes. You didn't hear my, and you would like?
Sorry, Your Honor, for the respondent, 5 minutes.
Okay, let's do 5 and 2 and 5. People versus Sterling Stewart.
Good afternoon, Your Honor.
Good afternoon.
I request 13 and 2 for rebuttal.
Okay. 5 and 2 and 5. Pereira versus 509 West 34th Street. Okay, no rebuttal?
Oh, yeah, 2 rebuttal.
Okay. Okay, let's do 5 and 2. Didn't you have a cross appeal? Okay, so you want rebuttal time on your cross appeal? Okay, 4 and 1, 5 and 1 and 4 and 1. Kohler versus West End 84 units.
Michael Fishman on behalf of the appellants.
Okay.
7 and 2.
Okay.
Christopher Servagey on plaintiff appellees,
6 and 1 and 6. Cedeno versus Boliki.
For appellants, 6 and 2, Your Honor.
Okay.
Good afternoon again, Your Honor. For respondent, appellate, 4 and 1.
Okay. 5 and 2 and 4 and 1. People versus Jefter Dominguez. It has 2 appeals. Again, it's going to be argued together, if at all. It appears it's a submit. Robles Lopez versus ESH Family Corp.
Appellant ESH requests 7 and 3, please, Your Honor.
Okay,
Respondent, new 5-star gold, requests 2 minutes.
okay, new 5-star gold. Did I misread the papers? Because I saw no one oppose or write anything about you, so as far as I'm concerned, you're good.
That's fine with me. One party said the order should be reversed in its entirety, and that includes me. So
Yeah, but they didn't argue anything below, and they didn't argue anything specifically about you, so as far as I'm concerned, you're good. Okay? All right, next argument time. Okay? All right,
Good afternoon, Your Honor. For the plaintiff appellant Robles Lopez. Only if the court needs any argument from me, Mr. Gold, that's me. He's appealing my arguments on hearing. If the court needs 2 minutes.
okay, 2 minutes, all right. And you? Okay, so ESH 6 and 2, Vista 5 minutes, Gene Star 5 minutes, and plaintiff 2 minutes. Stafford and versus A&E Real Estate is submitted. Board of Managers versus Worldwide Holdings is submitted. First case on the calendar, People versus Kejan Yazar. You may proceed.
Good afternoon, Your Honors. Mary Catherine Smith on behalf of John Yazar. The video evidence in this case calls for suppression. The body camera footage shows that Mr. Yazar asked if he was free to
Counsel,
leave.
we only get there if the waiver is bad, right? The waiver of right to appeal. Why don't you address that?
Yes, Your Honor. So the waiver of the right to appeal here misconstrued that the right to counsel on appeal would not survive the waiver. This is particularly important because if someone thinks that they are not going to be afforded counsel on appeal, if they waive, it's totally misconstruing what they're actually waiving and what they're not. Here, Mr. Yazar was 23 years old. It was his first felony conviction.
Was the model colloquy used?
The model colloquy was basically followed.
Is your issue with the model colloquy?
My issue is not with the model colloquy. I think it's with the structure of listing the right to an attorney on appeal as part of the rights that are being given up and not making it clear to Mr. Yazar that that right is not extinguished by the waiver, that he would have counsel on appeal. And I'd like to just emphasize.
Are you saying that the written waiver suffers from the same lack of clarity?
I think that the written waiver in this case compounded the lack of clarity in the written waiver.
On that particular issue?
Yeah, one moment. The written waiver said that the right to appeal would have allowed the assistance of an attorney. I think that that conditional language implies that the assistance of an attorney wouldn't survive the waiver. And in the,
How do you read that? Based on what you just read, how do you reach that conclusion? I don't understand.
I think because using the conditional language of would have allowed indicates that that is part of what's being given up, is this right to an attorney. And I'd like to just emphasize again that Mr. Yazar was 23 years old. This was his first felony conviction. He had just lost at the suppression hearing. If I may move on to the suppression issues, the body camera footage in this case shows that Mr. Yazar was told by police that he was not free to leave after he explicitly asked if he was free to leave. And it also shows that there was not a bulge.
Wasn't he asked to hang out? Is that being told not to leave?
Your Honor, I think that when the police officer said hang out, it wasn't a social invitation, it was a direction. Mr. Yazar says, "Can I leave?" The officer says, no, hang out here. And it's a quick interaction, but it's key. The reason that Mr. Yazar was asking if he was free to leave is because he felt that he wasn't. He was being interviewed by these police officers. He saw another group of police officers arriving at the scene. He had given them his license. He had been directed to show his hands. And a reasonable person would not have felt free to leave in these circumstances. But if this court doesn't agree with us on that point, suppression is also warranted on the second interaction, which is between Mr. Yazar and Officer Kirk. Officer Kirk testified at the suppression hearing that he saw a bulge in Mr. Yazar's jacket. I submit to you that a viewing of the body camera footage specifically shows that there was not a waistband.
That testimony was credited by the suppression court, correct?
Yes, Your Honor, and
And the suppression court's determinations with regards to that are afforded great deference, correct?
they are afforded great deference.
So why
but
should we not do that here?
I think that the video evidence belies that determination. Where you look at the video, you do not see a bulge. And you also see other aspects of Officer Kirk's
Was
testimony.
the video played at the suppression hearing?
Yes, both the body camera and the surveillance were played in full at the suppression hearing. Officer Kirk also testified that Mr. Yazar was blading his body, meaning to turn it to the side. A view of the surveillance footage specifically shows that Mr. Yazar stood in one place. And a view of the body camera footage shows that Mr. Yazar is wearing a puffy, voluminous jacket. There's no bulge visible. And nonetheless, Officer Kirk rushed onto the scene, frisked him, and then says at the suppression hearing, "I saw the waistband bulge." And as you all know, in New York, a waistband bulge is telltale of a weapon. And I submit to you that that testimony gives the appearance of being tailored to nullify any constitutional objection.
But
to the frisk.
I mean, you make these arguments as though these officers had not responded to a radio dispatch that there were three men or three persons standing in front of this building passing around a gun. But you'll be able to address that on your time in rebuttal,
Thank
all
you,
right?
Your Honor.
Good afternoon, Maria Wager for Respondent, the Bronx District Attorney's Office.
Counsel, didn't the court give the model colloquy on a waiver of right to appeal?
They did, Your Honor. The model
She
colloquy
went through
was
the
filed.
trial rights, the appeal rights, and his entitlement to counsel, correct?
Yes. And defendant confirmed that he was satisfied with counsel.
That he was
everything-
doing it knowingly and voluntarily,
Yes,
and he had counsel with him,
yes.
and he had discussed it with counsel.
Yes, active participation of counsel. There was also a written waiver, and that written waiver explicitly included the suppression issue, and that happened post-hearing. So defendant was well aware of the suppression issue he had. In fact, there was post-hearing memorandum submitted, and he decided to give up that claim. For the first time, he was offered a sentence that didn't include jail time.
He
And
got
so
5 years probation.
Yes, and he made that decision to avail himself of that bargain. And nowhere in that waiver does it say that the right to appellate counsel would dissipate. I think my adversary is reading that into the model colloquy and is in fact asking this court to find the model colloquy is no longer legitimate, and it's already gotten the stamp of approval from this court as well as the New York Court of Appeals. It should be enforced. I just want to point out that there's a second bar to defendant's claim that he never made the argument that he was seized by the uniformed officers to the hearing court. That argument was never made. At the hearing, his argument was he was seized for the first time when the plainclothes officers arrived and everybody was surrounding him and Officer Kirk touched him. In reply, my adversary says, well, it's the same thing. And it's not the same thing because a Fourth Amendment claim, as this court is well aware, conduct escalates, the police response can also escalate in response to defendant's conduct, and those are two different junctures in this evaluation. Would this court like me to address the merits of the suppression claim?
If you wish, you have 2.5 minutes left.
Yes. The hearing court didn't have a chance to determine this, but defendant was not seized by the uniformed officers. There was no lights, no sirens, no physical force. Nobody even touched him. And the reason they said, no,
Counsel,
hang
how do you
out.
respond to your adversary's position that the video, if you look at the video, you see the defendant in an oversized jacket. There is no bulge that's apparent.
I disagree with the characterization of a puffy jacket. Puffy jacket to me is a downwind winter
So
jacket.
let's eliminate that. Let's
Yeah.
change it to a big jacket.
Okay, it was a nylon jacket, and if you see, I think the video does corroborate the testimony that he was blading his body. You see as the plainclothes officers are coming, he turns to the building.
So
and
we
he's-
agree that blading the body in and of itself is not sufficient to establish reasonable suspicion.
It is not, Your Honor.
Okay.
But Officer
So you need
Kirk,
something else. You need the blading of the body, and in this case, the officer testified that it's the bulge in the waistband, correct?
yes, and if you see Officer Kirk, he first is walking towards defendant, and he has a flashlight trained at his torso. And what also corroborates that he saw a bulge is you'll see him. Now, the video is not the greatest. It's dark. It can also, the body cam is blocked by other officers. But what you see is he goes right to the exact spot in the waistband. That corroborates that he actually saw something there. He didn't just aimlessly feel around, he went right to that spot. And, you know, Judge Michael had an advantage that we all don't have. She heard the witness, she saw the witness, heard Kirk's testimony, saw the videos, and it's not impossible. Excuse me, the testimony as Kirk described it is not impossible, and her determination is should be given deference by this court, her findings.
Thank you.
Thank you.
Thank you, Your Honors. As to the question regarding the 911 call, I'd like to just emphasize that this was an anonymous report of 3 black men outside of a building showing a gun to one another. Only one was given a physical description. He was described as 35, skinny, and 5'7". When the police arrived at the address, they found 2 men and a woman. Mr. Yazar is 23 years old, he's 5'9", and he's rather stout. I wouldn't say skinny. So he didn't match the physical description. I'd also like to address...
But it was only one description, so we don't know what the other 2 look like.
Yes, Your
right?
Honor, but the
Okay.
prosecution didn't adduce proof of the other person matching the
Right.
description at the hearing. And then I'd like to just briefly address the preservation argument. The defense counsel below did bring up many of the same facts. If this court finds that that claim is unpreserved, we would say that the second claim regarding Officer Kirk is meritorious, that it was well preserved. And I'd like to just quickly note that a close view of the body cam video shows Officer Kirk starting on the right leg and moving his way up the body, not going straight for the waist. Thank you.
Thank you. Badesh versus Fort 710 Associates. You may proceed.
Good afternoon, Your Honors. May it please the court. Hal Bierman of Greenberg Trarg on behalf of defendant, appellant Fort 710 Associates, LP. Supreme Court's order should be modified to grant Fort 710 its motion for partial summary judgment on respondent's third cause of action for rent overcharges. They seek the punitive default formula and trebling such damages. But the rules are clear, and the damages should be determined pursuant to the 4-year rule. This is another in a long line of J51 cases.
Counsel, could you address Malkowicz, please, which held that a pattern of raising rent above the deregulation threshold and then lowering it significantly below the threshold can be indicative of fraud?
Your Honor, this unit was restabilized before this action was brought. So the only reason it was restabilized was because of the DHCR guidance. So what happened here was this.
But there was a hiatus, was there not? Gersten was decided in August of 2011, and then the apartment was leased as unregulated in December of 2011, several months later.
So in spite of the decisions of the courts, your client went and deregulated an apartment that the case law said he could not do.
Your Honor,
The fact that DHCR took another 5 years to give an opinion is of no import.
No, Your Honor, the unit was actually first deregulated on the day Roberts was argued at the Court of Appeals.
That doesn't matter.
It was 2009 when it was first deregulated.
The question is whether it was deregulated properly.
Of course, Your Honor.
Right.
But there was no question before the lower court about the proper deregulation.
Counsel,
In
then
order
no-
for that to happen, sorry.
Counsel, then not why wasn't, the landlord did not offer the tenant a new rent-stabilized lease or re-register the apartment until 2016, when DHCR issued a new rent guidance.
Your Honor, there
It was a hiatus of 5 years?
Your Honor, it wasn't a hiatus. There was great confusion in the industry as to what to do with a previously deregulated apartment. Nobody knew. That's why it took DHCR 7 years to come out with these guidance and principles. And as soon as they come out that year, it gets re-registered as rent stabilized to follow the law. There is clear First Department and Court of Appeals law that says delayed re-registration is not evidence of fraud. That's Casey, that's Tribbs, and this court in the Ordonez, the Second Department in Gridley held that as here, a delay to re-register until after DHCR issued its FAQ in January 2016 is not evidence of
But you're
fraud.
seeking a motion for, you're seeking a motion for summary judgment, right? Affirmance on a motion. You don't want to go to trial.
No, Your Honor. The reason we're seeking summary judgment is because the plaintiff bears the burden to show that there was a fraudulent scheme to deregulate. And we've been through discovery.
And the court felt that there was enough.
Your Honor, but the court erred, frankly, because
Okay.
the court did not.
Well, that's
come
why
up
we're here,
with-
right?
Exactly
And that's
right.
what we're here to decide.
If the court had identified a single scintilla of fraud, this isn't colorable claim. We
Really?
need to prove fraud.
Not a scintilla in this case.
There's not a scintilla, Your Honor.
Really?
Because there's,
It's not the plaintiff's burden, it's your burden, it's your motion.
Your Honor, it's my motion for summary judgment to say that the 4-year rule, the rule, not the exception, not the limited narrow exception, should apply.
Right, and in order to get that, you have to show that there was no fraud.
Your Honor, they have to prove fraud. And in opposition to summary judgment, they have to lay bare their proof. They came up with nothing because there is nothing. So what are we going to go to trial? We're going to go to trial to have them prove fraud, or to try to prove fraud, and not come up with any evidence. There's no reason for a trial. Which
Well,
is
then
what
it
summary
should be a
judgment is
fast
for.
one. Have a good day.
Thank you, Your Honor.
Jodicy versus Sheila M. You may proceed.
Good afternoon, Your Honors. Eva Stein, may it please the court, Eva Stein from the Children's Law Center on behalf of the children who are the subject of this appeal and are now 9 and 4 years old.
This appeal should be dismissed, correct?
Correct. We believe this appeal should be dismissed because leave to appeal was not granted. It's an interim order that the mother seeks to appeal here, and it's been rendered academic. There have been numerous subsequent.
There's a new order now for Sundays from 12 to 4.
After that court date in February, in May, there's now another order that gives the father visits on Sundays for a longer amount of time. And then also there's going to be 3 consecutive Saturday to Sunday overnights starting at the end of June. And clearly the family court is in the best position to assess.
She's had this family for over 2 years and 2 years' worth of Safe Horizon and CFS reports, correct?
That's correct.
Okay.
If the court doesn't have any questions, I'll rest my.
Thank you so much for the update. Zang versus Chu. You may proceed, counsel.
Good afternoon, Your Honors. May it please the court, my name is Claiborne Hain on behalf of plaintiff appellant, prospective buyer Shinny Zhang. The Supreme Court's summary judgment order should be reversed because there's a genuine dispute of material fact regarding whether the time of the essence closing date was validly set, maintained, rejected, adjourned, or extended. The contract of sale did not set a firm closing date. Instead, it was on or about 30 days from the contract date. Critically, the contract did not provide that time was of the essence. Instead,
Well, that may be true. Is there anything prohibiting anyone that's part of that contract to then set a time of the essence date after the original date in the contract has passed?
no, sir.
So isn't that exactly what the buyers did? They set a time of the essence date?
Correct, but then there's a question of fact whether there was a reasonable amount of time, whether the 30 days notice for the TOE closing date was reasonable.
But wasn't that rejected by plaintiff?
That was.
Isn't that an anticipatory repudiation then?
Is not because the appellant still wanted to buy the house or the condominium. She could liquidate assets to do so and was ready to do so.
Say again?
The appellant was ready to liquidate assets in order to fund the entire purchase, regardless of whether there was a mortgage involved.
So financing was never a part of the bargain, right?
That's correct.
It wasn't a requirement that the buyer find financing. Why then was that posed as an issue subsequently?
That was the reason. The reason why the time of the essence notice was rejected is because the time was insufficient for her to finish everything she needed to do, including liquidating assets, as well as potentially find a mortgage. So then,
Wait.
Wasn't there an issue about condo
Wait.
approval?
Yeah.
Wait a minute.
You seem to be trying to have it both ways. You say in one moment, no, the contract has no financing aspects to it. And then you say she was ready and willing, she rejected the time of the essence letter because it wasn't enough time for her to liquidate assets or get financing. But that wasn't a part of the deal.
that's correct. Even if the time of the essence date was validly set, it was adjourned by a call on May 19th.
Well, there's an issue about that, isn't there? They claim that there was no agreement to adjourn it.
Respondent's own real estate counsel testified under oath that they did adjourn it.
But how can they adjourn it when you repudiated it? You said, no, we're rejecting this time is of essence letter. We don't want it. It's not valid. So how does it get adjourned?
To the extent the court finds that the time of the essence closing date was validly set and not rejected, it was adjourned by the respondent and the appellant when they met and conferred on
May
That's a
19th.
big, that's a big if, us finding and not rejected when you rejected it.
Sure,
How
yes.
do you get over that hurdle?
Regardless of which way you go on whether the time of the essence closing date was validly set, the adjournment, even if you find that the TOE date was validly set,
Your argument sounds like whack-a-mole. If not this, that. If not this, that. Come on. What is your position?
our position is the time of the essence closing date was validly set despite the rejection. Then subsequently, on May 19th, the parties met and conferred and decided to adjourn the closing date. In fact,
Okay.
one day before the call, respondent relisted the property for a higher price. Appellant relied upon the agreement on the May 19th call not to use the May 25th date as the closing date.
So are you saying that then they should have sent another letter out? Is that what you're arguing?
I'm
Because
saying-
they had a date, time was of the essence, and after that, your client came back and said, well, I'll pay you less, and the plaintiff, the seller said, no, you pay me what I want. And so there was never an agreement on price, and the closing date came and went, and nothing happened.
Right, nothing happened, including respondent did not prepare for, was not ready, willing, and able to close on that date. In fact, there were common charges that the contract required to be paid past tense prior to closing that were not paid prior to May 25th.
So who had to be ready, willing, and able on the time of the essence date? Wasn't it the buyer was supposed to be ready, willing, and able to, at that time, close on the deal?
For the seller to succeed on a breach of contract claim on summary judgment, they need to show that they were ready and willing and able to perform.
Well, they said that they were.
They've only said that they were in an affidavit, which does not have evidence to support it. In fact, the record shows that they were not ready to do so because they had not paid the common charges, which were required to be, they were required to furnish a document showing the.
I thought that the agreement and the deal was that from the payment, from the sale of the apartment, they were going to pay off the arrears in common charges. So that can't possibly be a basis for blowing the deal.
That's incorrect. And section 3.1.4 of the contract requires that common charges and assessments, quote, have been paid past tense, which they were not paid as of May 25th.
But why should they pay it? You rejected the time of essence on May 10th.
If they truly believed, and since they had the call on the May 19th, adjourning the closing date, if they truly believed that May 25th was still the closing date, they needed to do everything necessary to be ready, willing, and able to close on that date.
Didn't you, s-
Go ahead.
Didn't you subsequently try to negotiate a reduction in the price from the original price? So that, on the one hand, the year's payment that was supposed to be a security deposit would be credited as prepaid rent, and on the other hand, the original sales price of 1.375 million be reduced to 1.255 million. Didn't your client, who apparently had the money, you say, to close on this deal, ask to pay less?
After discovering
And get a year's rent?
After discovering issues with habitability, there were continued negotiations about the closing date as well as the price, yes.
All right, you'll have time on rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the court. My name is Vivek Suri, and I represent the respondent defendant in this action, Mr. Chu. Simple contract of sale, Your Honor, with riders that specifically state that common charges, mortgages should be paid off at the closing. There's no mortgage contingency.
What section of, he read to the court a section that required that it be paid? Is that the same section you are alluding to? So it's a question, let me finish my question.
No, Your Honor, section.
Counsel, let me finish my question. So is the difference, is it the same section or is it a different section?
Your Honor, the lower court cites section 2.13 of the contract and paragraph R8 of the purchaser's rider provides that these encumbrances to be paid off at closing out of the proceeds of the sale.
Which is not an untypical thing that happens at closings.
Yes, Your Honor. Hundreds of closings happen in New York City every day.
Yes, you pay off tax bills, all kinds of things at closing.
Yes, you have to provide a free, clear title, Your Honor, and that's what my client was willing to do.
Did your client agree to adjourn the time of the essence?
No, Your Honor. The contract provides that the attorneys could agree in writing to adjourn the closing date. That
There
never
was no
happened.
writing with regard to any adjournment.
Nothing has been provided, Your Honor.
No emails between each other saying we need to, because under our case law, an email is a writing. So was there emails between the attorneys with regard to adjourning the time of the essence date?
No, Your Honor. May 25th, 2022 was the time of the essence closing date, never adjourned by anybody on behalf of the defendant or the defendant's attorney in writing.
Counsel, I was curious about a line in the rejection of the time of the essence letter. So it said here that the buyer alleged that the seller agreed to a concession to obtain financing and therefore executed the amendment knowing that the unit is non-warrantable. What comment, if any, do you have as to the warranty of habitability or the ability to not gain financing?
Well, Your Honor, there was no question of any issues of warranty of habitability. At the deposition, the plaintiff and the appellant, Ms. Zang, testified that she was told by supposedly mortgage brokers that no bank would lend to this building. That was the only issue she raised. But the seller's concession was signed, but if you look at that rider...
Is this the same building that has non-functioning elevators?
I'm sorry, Your Honor, I don't actually know whether that's true or not.
Okay. How many stories is this building?
I know it's a high-rise, more than 20 stories. I'm not sure exactly how many stories are there.
All right. Go ahead.
So at the end of the day, Your Honor, the seller was, my client was willing to close on May 25th, 2022, but even before that closing date came, they rejected the time of the essence letter, and the lower court found that that was an anticipatory breach of the contract. Based on that, the lower court awarded summary judgment to my client. And we would ask that this court affirm the lower court's decision, because this is a very simple transaction.
It's not so simple. There seems to be issues of fact related to the back and forth with the renegotiation that was going on between the both of you. And so why isn't there an issue of fact that should be flushed out at a trial?
Well, Your Honor, because that all happened after the May 25th, 2022 time of the essence closing date. All the discussions that happened were trying to salvage the deal. The seller wanted.
But were there, I'm not certain from this record that there was a meeting of the minds on what the actual terms were for a closing on the 25th. So after the first date came and went, there seemed to be negotiations going back and forth between you.
Yes, Your
Okay?
Honor.
And one made an offer, the other one made a counter offer, et cetera, back and forth, and it was ultimately rejected. So where does that leave us? Why does that not create an issue of fact that a trier of fact should determine?
Your Honor, that does not create an issue of fact because what had happened was that all of those discussions took place after the seller had already, the buyer had already rejected the time of essence letter and the time of essence closing date and breached the contract on May 11, 2022. So based on that, we would ask this court to affirm the lower court's holding.
Okay.
Thank you, Your Honor.
Counsel,
Go ahead.
I'd like to quickly address the.
Counsel, I just have a question for you as to the fee application that the defendants filed.
Yes, ma'am.
Did the plaintiff have a reasonable opportunity to contest it?
They did not. The affirmation was filed over a month after the summary judgment decision. The plaintiff only had 48 hours before a final decision on the fee award was granted.
There was no hearing granted
There was no hearing.
for evidence to be submitted in terms of the bills and the time submitted,
Yes,
correct?
Your Honor. And quickly on the no oral modifications argument, the New York Court of Appeals in Rose v. Spa Realty held that, quote, a contract once made can be unmade and a contractual prohibition against oral modification may itself be waived. On top of that, the contract terms he's referencing, paragraphs 26 and 31, clearly demonstrate that it's limited to contract terms, not extra contractual terms that are rendered in an extra contractual notice, the TOE letter that they sent after the contract was signed. This case is exactly like LG 723, the Royal Development Incorporated. In LG 723, the Second Department held that tribal issues of fact existed regarding whether the seller orally waived the deadline for closing, irrespective of the contract's no oral waiver provision.
But we're not the Second Department, so let me ask you a different question, counsel. Subsequent to the May closing date, May 25th closing date, weren't there attempts made to close this deal whereby the seller agreed to change the price of the contract of sale so that the closing costs of the purchaser would be covered to give kind of a little boost?
That's correct. The parties continued to engage in negotiations and attempted to set closing dates after May 25th.
But the buyer didn't close.
That's correct.
You said the buyer was ready, willing, and able, but the buyer didn't close.
What I previously said is that the seller was not ready, willing, and able to close on May 25th.
Okay.
Thank you.
Thank you.
Thank you both. Thank you. People versus Sterling Stewart.
May it please the court, your honors. My name is Barry Krinsky and I represent Sterling Stewart in connection with this appeal. We have submitted a brief in which we have argued that a number of errors were made, the cumulative effect of which was to deprive the defendant of his constitutional due process rights to a fair trial. In order to, I believe, really understand the context of what happened in this case, we need to focus in, at least in part, on the behavior of a witness that did not testify, Candace Bertine. She is at the center of everything that occurs. To crystallize it in a few words, what happens is that Candace Bertine had a husband by the name of Sean Salters, with whom she had a son, son 8 years old.
So we know,
Son who she was
counsel,
working
we
with
know this.
the day in question.
Counsel, we know this.
She's talking to you.
Yes. What are the legal issues that you wish us to address?
The legal significance of this is the following. When Sean Salters gets shot by her current boyfriend, who becomes deceased in this case, approximately 1 month before this incident occurs. She, Candice Burton, is completely uncooperative, misleading, and deceptive to the police on purpose. That is
Look,
relevant.
we understand, I understand exactly what you are sharing with us, and I recognize that this particular figure in this case, to put it mildly, had some issues clouding over her, no question about it. But the jury heard all about that, right? And they also saw some pretty devastating evidence by way of video footage, right? Of the actual shooting, of a man shooting this gentleman several times wearing a distinctive jacket that your client was arrested in. Shortly after, the gun is found on him. There's a lot of evidence. So I say this to say, even if I agree with you that there are issues concerning her statements, isn't it harmless in light of the overwhelming evidence of guilt here?
I submit that it's clearly not harmless error in this case for the following reasons. And if I just can continue that thought for one moment, Your Honor. Because what happens here in this case is although there were countless numbers of people out in that area on that night at that time, no witness comes to court and testifies and points the finger at Sterling Stewart, saying that he is the person that they saw shot the deceased. No one does that.
So what about the statements of Tanya Benteen?
I'm sorry?
What about the statements of Tanya Benteen, who was part of the group of 4?
The statement by the mother?
Yes.
The mother only
Who identified the defendant, who said she had known him since his childhood, and what about that statement?
That statement, with all due respect, Your Honor, does not create a harmless error scenario, because the witness did not come to court and say, that is the person I saw shoot the deceased. She says she saw someone running from the scene. At that point, she does not know who it is. So it's not a scenario where you have an eyewitness identification of a witness who actually saw what transpired and points the finger.
The clothing of the defendant was distinctive, was it not?
The clothing is not that significant, I submit to Your Honor.
Just wait 1 minute. The clothing of the defendant was distinctive. Did not various people at the scene identify that clothing, and did not the defendant wearing that clothing run from the scene?
Yes, but what I would submit to Your Honor, if you let me just finish this thought for 1 second.
I think you need to finish my thought, counsel.
I'm saying that the key piece of evidence in this case, I understand what Your Honor is saying with all due respect, but I was there at the trial. The key piece of evidence in this case was an impermissible statement that was allowed into evidence over our objection.
Why was it not? Why was Tanya Benteen's statement not an excited utterance?
It's not an excited utterance, and it's not present sense impression. The reason I'm saying that is because the pattern of behavior of Candice Burton explains what happened. It's not an excited utterance. That's not what she blurts out at the scene. At the scene, after this incident, she tells the police she doesn't know who did it. She doesn't know who that person is.
Talking about Tanya Benteen, counsel, not Candice.
I'm talking about Candice Burton.
I know, but you're not listening.
Candice Burton.
Okay.
Tanya Burton did not come to court and pointed the finger at the defendant. Candice Burton told the police she didn't know who did it. She did not testify. She was setting this up so that she could tell the mother.
I'm giving you 2 more minutes since you were interrupted. Continue.
She was setting this up so she could tell the mother of the deceased, who was not a witness to this, that in fact Stewart shot the deceased. She made that up. She deliberately did that because she knew that she could not possibly testify at this trial because of her conflicted and compromised position, that she saw the father of her son get shot 1 month earlier. She deliberately did not testify against him and deliberately misled the
She saw
police.
2 people get shot. The father of her son the month before and her boyfriend right in front of her. But you'll have time on rebuttal, sir.
Okay, thank you, Judge.
May it please the court, Melancha Chanda. I don't want to belabor what the court has already said, but I'll try to be as succinct as possible, that there was overwhelming evidence of defendant's identity as the shooter. Not only did 2 eyewitnesses who called in 911 describe the jacket he was wearing, he was caught within moments and within eyeshot of Tanya Bertine running and then being caught by the police, and she did then say, "That's him, that's the guy who shot my husband." But more importantly, he was also found in that 20 seconds with the gun that the ballistics showed matched the shell casings and one of the bullets from the defendant's, from the victim's body.
Did Tanya Bertine come into court and testify?
She did.
And did she say that the defendant was the person that shot
She
her
said that
son-in-law?
she said she didn't see the shooting, but she saw the man run, and right immediately thereafter, and the person the cops apprehended was the defendant.
So I want to be clear, because as I understood the record, Tanya and Candace, together with the decedent, Mr. Brown, and an 8-year-old child, were walking together, the 4 of them, when all of a sudden Mr. Brown drops to the ground because he's been shot.
Right.
Am I correct?
Absolutely.
Okay. So, and he's shot in the back.
3 times.
So when Tanya says, "I didn't see who shot him," it's because she too was walking in the same direction of Mr. Brown when he was shot in the back.
Right, exactly.
So she says, he just fell.
Mm-hmm. But then, and also if you see a clear video too, she turns around right after he's been shot and she follows, her eyes are following who's running. And also you see the cops pull over within seconds, and then, you can kind of see the outline of the chase as well as corroborated by their body cam footage.
Right.
But so it's a continuous
And the video
event.
also shows that there are numerous people on the street. Am I right?
Absolutely.
That it becomes a bit chaotic. People are moving and running around, and that 2 people run toward the police, screaming, "That guy shot that man. That guy shot that man." Correct?
Absolutely.
Pointing at the defendant. And when the defendant is seized, they confirm that that's the guy.
Right.
Okay. I just want
All
to be
within
sure.
a matter of, I'd say, seconds to a minute and a half. So
I didn't misstate what is in the record.
Absolutely not, Your Honor. I could talk about the witness statements from Candace Bentine, but I also do want to point out that defendant never asked for a missing witness charge until it was too late with respect to Candace Bentine. So if this is a problem that he is stating now in appeal, he had the opportunity to ask for a missing witness charge in a timely manner. But also those were excited utterance that did not violate Crawford. I could go on with
What exactly was an excited utterance from Ms. Bentine? Because my understanding is that the victim's mother testified that she received a phone call from Ms. Bentine in which Ms. Bentine said that Stewart shot Pookie.
Right.
Right? Is that statement an excited utterance?
That is what the court properly held, and that's our position because it was made.
Now, your adversary just argued a few minutes ago that it could not have been properly an excited utterance because moments before that, Ms. Candace had denied to the police that she knew who shot the victim.
Well, whether she was telling the truth to the police.
Well, that's
is a
problematic,
separate.
right? No, well, let's flesh that out because when it comes to excited utterances, the purpose behind excited utterance or the theory behind excited utterance is that when a person is still under the influence of a startling event, that they don't have the faculty or the wherewithal to think about or come up with some contrived lie or some other story. So here we have the witness in one hand telling the police, I don't know who shot him.
Right.
And then moments later calling them up and say, Stewart shot Pookie. They're inconsistent.
Well, I would submit that there's a law enforcement aspect to it that
No,
Isn't-
what do you mean?
What's the law?
To excited utterance, there's no law enforcement aspect to it. Excited utterance is simple.
It's about the declarant.
Right. Is the person under the effects of the startling event, and did the person have time to reflect? And here, clearly, how can you make the argument that she did not have time to reflect when, on the one hand, she's telling the police, I don't know who shot him, probably because she has this disaster a month before where she's a witness, right? And now all of a sudden, she's calling the victim's mother saying, I know who shot him. Inconsistent.
Well, I would submit that if you even take her statement out, there's plenty of evidence
That's
that.
another question.
Right, which is why I said what I said
There
earlier.
is plenty
that
of evidence
even
that
if-
he was.
Even if it is, even if I agree with him, that Candace's statement doesn't qualify as an excited utterance, and I'm just talking about Candace's statement, that there's still more than ample evidence in the record to support this conviction.
Including 2 other witnesses who were there at the scene.
And a ton of
being
video.
present. I'm sorry?
And a ton of video.
Oh, absolutely. And then also the matching clothing and the ballistics evidence that really linked the gun and the bullets to the bullets that were shot into the victim. So,
Thank you.
thank you, Your Honor.
Counsel, you have 2 minutes.
I just want to pick up on that point that Your Honor raised, because I think it's critical to this case. I understand you're telling me I was there, I was at the trial, I had to deal with all the evidence that came in against my client. However, the one most significant...
So was the judge at the trial. So you're telling me that, oh, I'm at the trial, is a little bit kind of offensive?
No, I don't
because
mean it in that way.
we
I don't mean
get
it-
the entire record,
I understand that, I'm sure
okay?
you're all ready.
And as you can see, we've gone through it.
I'm absolutely sure of that, Your Honor. But the point I was just trying to make is this, that the most significant piece of evidence in the case, I would submit, is the statement made by Candace, which she deliberately said to the mother of the deceased, approximately 15 minutes after she had told the police she did not know who had shot her son. She deliberately said to a witness,
We agree with you. So, and again, so even if we agree with everything you say about Candace, right? And that her statement should not have been admitted in, why is there still not sufficient evidence in this record to support the conviction?
because I submit that there are other issues which I have raised in my brief, which I would ask all of your honors.
What about the video, what about the video footage? I mean, there are at least 7 video clips.
I understand. What I'm trying to say is that no eyewitness identified the defendant in court as the perpetrator of this crime.
We got the gun on your client that matches the ballistics of the bullets that pierced the aorta of this victim.
I would submit to Your Honor that the ballistics evidence in this case was questionable at best. And in fact, there was numerous errors made in connection with the ballistics evidence.
Counsel, your client was running with the red and black checkered marks across the shoulders. Red and black checkered marks, in addition to the videos and the gun.
The last expert the gun expert that testified that the bullet or the bullet fragments found inside the body of the deceased could not be determined to have come from that gun.
Okay, well, the jury heard it, they made a verdict, and we have your case. Thank you so much for your argument, sir.
Thank you, Your Honor.
Pereira versus 509 West 34th Street. You may proceed.
Good afternoon, Your Honors. May it please the court, my name is Virginia Harper. I'm from the law firm of Cullen and Dyckman. We represent 509 34th Street.
Did you bring that mic a little closer to you?
Yeah, I speak lovely, I'm sorry.
That's okay.
And Tucker, I'm sorry, Turner Construction in this matter. Your Honor, this is probably the most legalistic case you're going to have today. The court below misconstrued the law about what an integral item is in the construction of concrete.
I've read your briefs. Your argument is basically that you're entitled to dismissal because his fall was the result of work that was integral to his work and therefore not something that you can be held liable for, right?
Your Honor.
Now, with regard to that argument, am I correct about the following facts? That this plaintiff was working on the 8th floor on this day, and that they were missing enough pipes to do the work on the 8th floor, and the plaintiff, together with 3 other workers, were then sent to the 9th floor to go pick up material to finish the work on the 8th floor. Am I right about that?
That's right, they had to pick up the hoses, what they call pipes.
So that when they went upstairs to the 9th floor where he trips and falls, he's not actually working up there, he's just getting material.
Right, that doesn't matter.
Oh, yes, it does. Our case law absolutely says that matters.
Well, I have case law here, Krasinski and Thomas versus Goldman Sachs, 109 AD 3rd 412, First Department 213, Deliso versus State, 69 AD 3.
You have your briefs. You don't have to read the citations into the record.
All right, so
but feel free to argue any particular case and the facts so that I can understand why you think those cases mean you win.
Right, they hold, like in Deliso, and I know this case because it was mine. Deliso, a man was walking across on a vessel, and there was a hose that went across the vessel, and it was doing some other work, and he was carrying something, and he tripped on the hose.
He was working in that area, though, no?
No. He was carrying, it's almost exactly like this case. He was carrying something or transporting something from one end of the ship to another end, and he tripped on this hose. And he said that, I wasn't working on this hose, but they held that this hose was integral to the workplace.
But counsel, shouldn't we really be looking at Jodicy to determine whether or not there was a sharp projection from the wire mesh? And in that vein, was a sharp projection established, or is there an issue of fact?
Well, I don't think there's an issue of fact. I will say this, Your Honor, before I get into the sharp projection, that the integral to the workplace argument gets rid of every other argument in the case.
If we accept it.
If you accept it.
Let me just ask this. So you're saying that the wire mesh is integral to the work of laying down the concrete, right? But in you putting down the wire mesh, you can't be negligent, right? So if you could put down the wire mesh in a fashion that doesn't leave any protrusions, sharp protrusions, then you're supposed to do that.
Yeah, but this is
and
not.
And the evidence here was that the wire mesh in most parts, absent the part where he tripped, was tied down.
Right. This was tied down. That's a question of fact. But in this particular.
But would you agree
Glad to
with the
hear
premise?
you say that.
Would you agree with the premise that if, assuming that the wire mesh is integral to laying of this concrete, that if you lay it negligently and that you leave some protrusion where someone could trip, that does away with your integral to the work defense?
No.
So you mean you
I
could lay it
disagree.
however you want then? No matter how negligent you lay it,
well,
just
I'll
because you
tell
need
you.
it for the concrete, it's okay?
There's a case where there was a piece of concrete.
Can you answer his question?
I'm very sorry, Your Honor. I'm trying to answer your question. That there was a case where there was.
That's not answering the question. The question is, are you saying that you can lay this wire mesh negligently, and because that is part of his job to deal with this wire mesh, it doesn't matter? Is that what you're arguing?
And yes.
Yes? You can negligently set a space for workers to work, and so long as that's part of his job, it doesn't matter?
Well, not in this case, because it's, first of all, it's an integral part of the workplace.
Didn't Basdrick say otherwise?
What case, I'm sorry?
Bazdaric.
Bazdaric.
No, I know what you're talking about.
Mm-hmm.
Bazdaric.
There it said, no, you can't do that.
But Bazdaric is totally distinguishable on
It's
facts.
a different set of facts, yes.
But
But
it wa-
counsel, when I'm talking,
Very
you
sorry.
shouldn't.
I'm very sorry.
Because I'm gonna give you time to respond to what I
Thank you.
say, okay?
Thank you.
All right, so in the case I just referred to, the workers said to them, this covering that you're putting on the escalator where you want me to paint is dangerous. And the defendants argued, it's integral to the work. We have to protect the escalators from the paint, so too bad, work on this surface. And the court said no. The Court of, I was in the dissent here, and the Court of Appeals said no. They agreed with the dissent. You cannot create a negligent circumstance where a worker can get work and then say it's integral to the work.
You're
So
absolutely.
I'm sorry, you can't, that's not accurate.
I agree with you on that case, okay? Because in that case, they used the wrong type of covering, and the worker said to them, this is the wrong covering, it's dangerous, I'm gonna slip. And it's exactly what happened. That covering was not going to be put in as part, or installed as part of an escalator, all right? In our case, the wire mesh was there because it has to support the concrete that's poured. It's going to be part of it.
Right.
All right, so it was
But
ready.
but you're saying that can be laid negligently.
Yeah.
And it doesn't matter.
Well, first of all, their negligence claim was dismissed and they didn't appeal it. So that's number one. Number two, we're narrowly speaking with the 241-6.
I know.
Based on, right, you know what it is, what it's based on. You're saying, is there a violation? Can 1.7E1 and 2 be used to support a 241-6 case if it's laid negligently, but it's still an integral place
It
of
has to be free from obstruction, counsel, so that
Right.
it doesn't cause tripping. That's the E2 portion.
That's right.
of
But,
the-
Your Honor?
That's the E2 portion of the industrial code.
Yes, and
And it
this
doesn't
was ready
say,
to be
it
laid.
doesn't, it
This
does,
wa- Nobody was working on
counsel,
this?
you know what? I won't say anything because you have so much to say. That's,
I'm sorry, Your Honor, I don't mean to speak, but I mean, this is really black letter law. There's all the cases in our brief.
Thank you. You'll have time on rebuttal.
Thank you.
Good afternoon, may it please the court. Vincent Chirico for the plaintiff respondent, Mrs. Pereira.
Can a defendant negligently provide space for a worker just because it's integral to the work?
No, Your Honor. And to your question and to Justice Rodriguez's question, this steel mesh was upright when it should have been laid down. It was untied when it should have been tied. It was a little loose when it should have been firm, and it caused them to trip. That is clear negligence. That's the clear sharp projection under 1.7E2. I recognize Bazdaric. I think Bazdaric is on all fours, and I'll raise you a Rusich, where in that case, there were concrete pebbles on the ground that were part of the flooring inherent to the flooring. And the Rusich Court of Appeals decision held that that was not integral to the court because, to the work, because it was avoidable without obstructing the work or imperiling the worker. So this case, in my mind, is exactly on all fours with Rusich, with Bazdaric. It's a clear sharp projection, and it's a clear condition which can cause tripping.
Well, counsel, let me just push back a little bit on that. Is it a clear sharp projection? Because I'm not sure that the record fully establishes that the plaintiff even was fully aware of where he tripped. So isn't that a problem?
No. This is the Leonard case, Your Honor. And you know, any projection that is sharp in the sense that it's clearly defined or distinct. Leonard was a doorstop. Jodicy, which I argued several months ago, was a nail that was sticking up. It's the same factual scenario.
Does that sharp object have to cut you?
Sharp object.
Does that sharp object have to cut you, as the defense tried to argue?
No, it has to cause tripping under 1.71 and 1.72. If I may go on, there's no question that this area is a passageway, no question that it's a working area.
Is it a
How is it a
passageway? I don't know
passageway?
about
How
that
is it a
part.
passageway?
Well,
The E1 part is a little tricky for you, so maybe you want to talk about E2 more.
well, E2 I think is stronger, and I agree with Your Honor, but I will point to page 246 of the record. And 246 of the record has plaintiff's testimony that says they had to walk a path, a discrete path. This is a whole open floor, but he had to walk a discrete path to get to the pipes and to come back. They didn't even have a cart. There was no plywood laid down. They knew they weren't supposed to walk on the exposed rebar, and they were forced to do so, and they walked this discrete path back.
The photograph that's part of the record shows a wide swath, I'm going to call it,
Yes.
of mesh. It doesn't show a path.
I concede that.
So
I
so
certainly concede
passageway
that.
doesn't exactly fit.
But this is also the Sansino case, all right? It is an open area, and normally that open area doesn't qualify as a passageway.
Right.
I do concede that. However, when you have testimony that says, yes, we had to walk a discrete path, and by the way, the photographs don't show where the accident happened, the location of the accident. That was plaintiff's testimony. It could have been there, but these floors all look alike. So there's no definitive location of the accident on the photographs.
So how do you meet your burden of proof in that regard?
With plaintiff's testimony. He described the scene, he described the pathway that all of the four workers took going back and forth, and they were afraid to walk anywhere else on the floor because once they knew the rebar that they were stepping on, they were afraid to move outside of that area from the elevator where the cart was located all the way to where the pipes were and
So
back.
a cart would have only been useful if there had been plywood strewn across this mesh surface.
Yes, and I grant you that had there been plywood, then it would have been a better defined area. So that's where my argument on 1.71 is relatively weak. But I did need to point out the defined pathway that plaintiff testified on.
Was the plaintiff supposed to be walking on that wire mesh?
No.
Unless he was pouring concrete?
That's right, Your Honor. He knew he wasn't supposed to be there. The only time they can walk on rebar is when there is plywood on it or when they're pouring concrete. It was not his job to pour concrete. His job that day was, as Justice Mansden had indicated, to work on the 8th floor and to pour concrete on the wall.
So this floor, the 9th floor, that had the wire mesh on it was ready for concrete to be poured, but they were pouring concrete somewhere else.
Right, and the foreman knew that they really weren't supposed to go up there, but he needed these pipes, and on an emergency basis, everybody called this an emergency. And he directed Mr. Pereira and his co-workers to go, just hurry up, go get them, because we need them. And that's another area of negligence
So he was not there to pour concrete, he was just there to pick up a hose.
That's right. His job was to pour the concrete on the walls on the 8th floor.
And that was not the task at hand that would have made this integral to the work.
That's correct, Your Honor. No other questions?
Thank you.
Thank you.
Your Honor, it was never really established that this was a vertical piece of rebar. The plaintiff stated that it was a little upright. Didn't say it was upright, a little upright. And then, when he went up to investigate with Maria Aloha, he couldn't find the area. Now, if this rebar was sticking up, why couldn't they find it?
So you're saying that there was no sharp projection?
There was no sharp projection. There was not. And this, frankly, it wasn't a work area because this area was supposed to be ready to be poured.
So isn't this an argument to be made to a jury? As opposed to a legal argument to be made to the court?
Frankly, Your Honor.
Because you're talking about credibility issues. Do you believe the plaintiff that there was a sharp projection when we couldn't find it after the accident?
He couldn't find it after the accident. He also said it was a little upright, which wasn't very clear. And he also...
But he did say he tripped.
He did trip. We are not disputing that the man tripped, but it doesn't mean that there was a problem with how this rebar was. And by the way, we submitted expert testimony that was not rebutted in this case. Our
Unrebutted.
expert, it's unrebutted, and they just haven't made their burden of proof that our expert should not be believed. Our expert looked at these pictures, said there's nothing wrong with this rebar, that the only securing that anybody cares about is horizontal securing so that the mesh tiles stay in place. When you pour the concrete, that actually floats up to midline, and they want it a little bit wavy.
Thank you.
Because of the, so, thank you, Your Honors.
So two quick points on the expert. This expert did not inspect the accident location. He concluded that there was no dangerous condition based on the photographs which did not show the area of the accident, as plaintiff testified. It ignored Mr. Pereira's affidavit where he said he had to walk across it as an emergency basis. So there's no probative value to this expert, and we did address it in our brief and in the court below. On the whether this was a significant enough tripping hazard, this is Jodicy. Jodicy was a half-inch nail that was sticking out of a poured concrete floor. It's irrelevant as to whether this upright piece of mesh was half an inch, a quarter inch, 3 inches, or whatever. It caused him to trip. That was his testimony. He wasn't sure if that was it, but he testifies at 245, 249, and 250 of the record that it was upright, it was not tied, it was a little loose, and it caused him to trip. There's no doubt about that. That's the only evidence in the record. This upright mesh caused Mr. Pereira to trip.
Thank you.
Thank you.
Kohler versus West End 84 units. You may proceed.
Good afternoon. Michael Fishman on behalf of the appellant Phillips Nizer and Elizabeth Adenolfi. It seems like this world is full of conspiracy theories, and that's kind of bled into the legal system. But fortunately, as the state legislature has expanded the anti-SLAPP laws, and in connection with this court's rulings in Sweet Pea and in Black v. Wigdor, and most recently in Bar Fluid, there's a line that's drawn in the sand here. And you can't bring these kind of cases, you can't allege the conspiracy by a lawyer. You can't argue that the lawyer is fabricating evidence and creating documents, and in this case, allegedly intentionally fabricating the existence of an FBI investigation without bringing some facts to the table. Your self-serving affidavits
It would
aren't
be
going to help.
interesting to know, though, who reported the false and unsubstantiated allegations against Ms. Eggert to the FBI. That would be an interesting piece of information that would help in addressing this argument you make about conspiracies.
Well, Your Honor, we do have a document, a suspicious activity.
We don't know who reported to the FBI, but what we do know is that it was unsubstantiated because nothing happened with it.
Well, what we do know is that
So why don't we get to the facts in this case
Well, what we do know-
instead of all of this?
Well, what we do know is that Ms. Adenolfi and Phillips Nizer don't come into the picture until February, March of 2022. Whoever filed the suspicious activity report concerning Ms. Egerud that apparently generated some investigation over a long series of months, did that in June of 2021, long before we got involved in this. What we have here is a lawsuit against a law firm for having crossed its T's and dotted its I's. Phillips Nizer did not bring this petition to seek a guardian in behalf of Mrs. Kohler.
Let's back up 1 second, counsel. So the New York Post was contacted by Miss Eggert's, am I saying her name right? Egerud? Egerud's employer, am I right?
Yes.
And then NBC contacted Miss Adolfini?
Adenolfi.
Say again.
Adenolfi.
Adenolfi. and she released a statement to NBC.
Yes.
Okay, is that covered by the anti-SLAPP statute?
Oh, yes, it certainly is. And by the litigation privilege. I mean, coming back for just a brief second to to the FBI, what we also know from the record is that Ms. Adenolfi and another partner at Phillips Nizer was in contact with the agent from the FBI, who was asking Ms. Adenolfi and my partner and Ms. Adenolfi's partner for documents, and actually told Ms. Adenolfi and the firm that it could disclose the existence of an FBI or an investigation, asked not to have the FBI identified. But
Which was ignored. Go ahead.
it was not ignored. The petition does not make reference to the FBI. The petition does not make reference to anything other than an investigation by law enforcement. And in fact, when Ms. Adenolfi goes into court on March 7th of 2022, she tells the court that I can't tell you who's investigating this. But meanwhile, fast forward, there was no issue, it was undisputed within the guardianship proceeding that Ms. Egerud, they chose not to litigate it because Ms. Egerud admitted that she was under investigation by the FBI. It was not an issue. It ultimately turned out that there was nothing wrong and whatever happened with the FBI is cleared. But we have nothing to do with what happened in June of 2021. Any different than in bar fluid. Court, the lawyer checks with the employees to see if what was happening in the bar was actually happening. And takes his affidavits, crosses his T's, dots his I's, does his homework, and files a lawsuit. You can't go back and then sue the lawyer.
Who filed the order to show cause to commit Ms. Kohler? Who did that?
Ms. Adenolfi, on behalf of a client.
And that was against Ms. Kohler's wishes, and I venture to guess, probably without even consultation with her.
Ms. Kohler you're talking about?
Yes.
Yes, Mrs. Kohler was in a rehabilitation center in Riverside.
So does that mean that she can't be talked to?
At the time.
Her being in a rehabilitation center is not like being in jail.
No, Your Honor.
Okay, so you could go and speak with her and do your due diligence and make sure that this person is not competent and needs to have.
There was no issue in the guardianship proceeding that Ms. Kohler fortunately lacked the competence to care for herself or take care of herself or handle her affairs. Right then, we had Ms. Egerud in the lobby.
She didn't want to be removed from her rent-stabilized apartment, right? And that was the whole, I suspect, the basis for filing the order to show cause to have her committed into a nursing home.
Well, Your Honor.
So that we can get that apartment.
It doesn't make a lot of sense to go in to try to do that with a 92-year-old woman in a nursing home after a hospitalization, but take that aside. Judge Sharp considered that issue. They could have litigated that issue. The judge determined at the petition, in the hearing, that there was no evidence that anyone was trying to remove Ms. Kohler from her apartment, and she still lives there today.
That's what she found?
Yes.
I don't think so, but go ahead.
I mean, she did in fact determine, and if you go back, and I'll give you the record reference, if you look at page 1304 in the record, Judge Sharp specifically stated that there was no evidence that anyone was trying to evict Mrs. Kohler.
I didn't say evict. That's not the only way you get rid of somebody, right? That's not the only way. But you'll have time on rebuttal, sir.
Good afternoon, Your Honors. Christopher Cerbegy for the plaintiffs and appellees.
Counsel, if the defamation claim is dismissed, does that subsume the abusive process, the intentional infliction of emotional distress, and the claims?
No, they're all based on separate set of facts, Your Honor. Would you like to talk about the defamation claim? Because I believe it's very strong.
You can talk about whatever you want.
Do you have specific questions about that? I'd like to address whatever you
Make your argument.
Yeah.
Okay. Number one, she didn't admit, Ms. Egerud never admitted she was under FBI investigation. What she submitted an affidavit at record 2126 to 27, where she explained that the FBI called her at one point in time and asked her, what's going on with this. She explained everything. She said, you can have all my records. This was months before the guardianship was filed. And they said, okay, you're good in November.
Is she really disputing whether there in fact was an FBI investigation?
It appears
to me
that
she was.
she's disputing that she was the subject of an investigation. They called her before the guardianship was filed. They asked her some questions, and that satisfied the FBI. They dropped it. Yes, we would like to know who filed that. It will be very interesting when discovery proceeds. So 3 months later, they filed the petition claiming she was under criminal investigation. So she doesn't dispute that maybe she doesn't know whether the FBI was looking into somebody, but they certainly weren't looking into her because the report says they weren't looking into her. They closed it on December 9th, 2021.
And I want to ask you a question.
Wait, December 9th when?
21.
Okay.
Yeah.
3 months before the petition was filed.
And I want to ask you a question about the closing of the FBI investigation. The FBI indicated that it was closed because Ms. Kohler declined to speak with them on 2 occasions, right? So there was in other words, the closing had to do with, I'm going to call it procedural issues, loosely.
We don't know.
We really don't know exactly. The report says something like that, but we don't know all the reasons that they didn't look into it. We do know that they called.
What does the report say as to the closing?
The report does say that Ms. Kohler declined to speak with them. That is true. Absolutely. But they also called Ms. Egerud, who said, look at all my financials, look whatever you want.
She refused, just to be clear.
Yeah.
She refused to speak to them about their receipt of a complaint that she potentially was the victim of elder abuse. So if she thought she was the victim of elder abuse, one would assume she would answer their questions and cooperate.
That's also true.
Okay.
That's a good point, Your Honor.
Or alternatively, a person could decline to cooperate precisely because they were intimidated as a victim of elder abuse.
It's speculation. We don't know.
Well, yeah.
And it could be, but it's certainly, we know it wasn't Ms. Egerud, because Ms. Egerud offered everything that she had, financials, bank statements, anything, to the FBI. And the FBI looked at it and called her back and said it's closed. Moreover, the petition talks about how somebody who did have access to her accounts, Ms. Gentile, who was one of the defendants, did look into it, did call the bank, and the bank has a tape of Ms. Kohler transferring the funds to another account or something. So it was, and she even admits that in the supporting petition, which is why
And that person is related to the building,
She's
correct?
related to the building. She's the treasurer on the board of the building.
Of course.
And she,
And $100,000 was
$150,000.
$150,000.
well, there's dispute about what exactly the number is, 100, but it doesn't matter because what Gentile says in her supporting affidavit, which is why they never should have filed the petition, and this court recognized this a year and a half ago, that the money was not transferred to Ms. Egerud. There was no, and she even admits there's no evidence that that Ms. Egerud did anything wrong. Gentile says that in her supporting affidavit. They go to court on the first hearing, which was a complete surprise and sandbag. She's in the hospital. I'm at the time trying to communicate, hey, why weren't you
She's in the
inviting?
hospital, and I don't want to mispronounce her name. Ms. Egerud tries to get into the apartment with her power of attorney, correct?
Correct.
And they don't let her.
That's correct.
And counsel then says, what are you doing? Do we need to go to court?
It was me, and I said, trying to, not having any idea that they had already filed the petition, which shows the bad faith. On March 1st, they filed the petition.
And they filed an Article 81 petition.
Yes.
To protect her.
But in between.
If that's what you believe.
But counsel, in between, isn't there a request for an acknowledgement of the power of attorney pursuant to the general obligations law?
So, yeah.
Does that happen? Is that turned over?
I'm glad you raised it, and I think I talk about this pretty clearly in my brief, although there's a lot there I recognize. On March 1st, they filed the petition. Their other attorneys had talked to Philip Snyder before that, trying to work it out, a mediator. Hey, what's going on? Why aren't you abiding by the power of attorney? Then I get involved, and I'm saying, let's set up a call. Let's talk about this. Why won't you? Having no idea that they had already filed a petition. At one point, Mr. Fishman says, so send us an acknowledgement affidavit. I say, well, let's get on the phone and talk about this. And the next day, they notify us that that there's a hearing and they notice us on a Friday that there's a hearing on Monday. So I never refused to provide it, and Justice Frank recognized that.
Did you threaten litigation when you asked for the acknowledgement of the power of attorney?
Can you repeat that, Your Honor?
Did you threaten litigation when you were requested for the acknowledgement of the power of attorney?
I don't think it was subsequent to that. I think it was probably before that. They had canceled a number of phone calls, and I had said, let's get on the phone and talk about why you aren't abiding by this attorney. And then they asked for an affidavit, and the next day they say there's a hearing on a Monday. So I never refused to provide that affidavit, and that will be a fact question, and that's what Justice Frank said.
Okay.
Correctly, that it's a little unclear from the record. What is clear is that you had an attorney, me, trying to work this out to avoid all this, and it turned out they'd already sandbagged her and put her under guardianship, as Your Honor pointed out, without talking to Ms. Kohler, without talking to Ms. Egerud, and without talking to me. If they really cared about her and wanted to protect her,
And Ms. Kohler has no one. Her child died, so it's just her.
it's just
She has
her
no
and Ms.
family.
Egerud, her best friend, who has taken care of her diligently, and thanks to this court for reversing the guardianship, she has lived under her good care for the last 2 years in excellent health when she was dying in guardianship. And they were making funeral plans for her because, when you separate somebody from their family, from their friends and their loved ones, well, that causes big problems in the elderly.
Thank you.
And thanks to the decision of this court, she's been living under the good care of Ms. Egerud since.
Thank you so much.
Thank you.
You have a minute on rebuttal.
Thank you. Just a few quick things to clear up. Mr. Serbigi says that by the time he had made a request and that he never denied giving a affidavit for the power of attorney. That's just simply not true, and you'll see in the record. And there were threats of litigation, and there were multiple threats of litigation. The West End was basically had an impossible situation. And by the way, the guardianship proceeding was commenced on March 4th. We were having this dialogue on March 1st. But here we are. Phillips Nizer is.
Well, but that means you filed the papers beforehand.
We filed the papers March 4th.
Okay. I'll check that.
Okay, thank you. And you'll see, we filed the papers on March 4th. We were having these discussions, these dialogues, and these emails March 1st. Mr. Serbigi actually told me that it was too late. We had asked, 10 days had elapsed since we had received the petition or the power of attorney, and I pointed out that it was 10 business days and we were still waiting for it.
It's unfortunate because all that game playing, gentlemen, could have avoided all of this.
Well, Your Honor,
okay?
We were in contact with the FBI. We were looking at an FBI investigation that we didn't want to leave poor Mrs. Kohler.
Poor
Yeah,
Mrs.
okay,
Kohler.
please. Until I find out how the FBI got that complaint, I'm gonna reserve opinion about the, poor Mrs. Kohler, okay?
I think
But thank you, sir. Thank you so much. Cedino versus Boliki. You may proceed, sir.
Thank you, Your Honor. May it please the court, Devin Ness of Herrick Feinstein for appellants, the landlord. As Your Honors are well aware, this case involves a dispute over a lease and whether there is an applicable lease and what the applicable terms of the agreement are. Respectfully, the motion court erred to the extent that it failed to explicitly find that there is a binding agreement here, that agreement being the fully executed lease that's in the record. And the court further erred in failing to grant appellant's motion for summary judgment, finding that the tenants breached the sublease. As established by the documentary evidence in the
Counsel, you're saying that the fully executed lease was not binding? Can you explain that?
I'm sorry, Your Honor, maybe I misspoke. Our position is that the fully executed sublease is the binding agreement between the parties. The tenant takes the position that that lease was altered after execution and that it doesn't contain the actual terms that were agreed upon between the parties. But in our view, that's directly refuted by the record evidence, including in particular contemporaneous email correspondence between the parties, which establishes that the revised lease, which became the fully executed lease, was provided to the tenant prior to execution, and then so that was circulated on July 2nd in an email from July 2nd, 2018, by email from the broker, which drew attention to the changes in the lease from the prior proposed lease. Specifically, there were changes to the security provisions in the rider, which provided for a full year security deposit rather than a year of prepaid rent. So on July 2nd, 2018, the broker circulated the new lease terms. The same.
So I recognize that that part of the agreement changed,
Correct, Your Honor.
right? But doesn't your client then ratify it? And in light of that, isn't she now stuck with that?
Again, Your Honor, we represent the landlord, and we believe that that lease was ratified and that we think those terms are fully enforceable. We believe that it is a binding agreement and that tenant never performed under that lease, and that is the basis for our contention that the lower court erred in failing to grant summary judgment in our client's favor.
Wasn't there a time when the purchaser showed up with the proper checks for the 1-year security deposit, with the 1-month rent, and with checks to pay for the broker's fee and with insurance, and was ready to close on the deal?
Respectfully, that's partially correct, Your Honor. On August 1st, 2018, they showed up and they had the incorrect checks completely, so there's really no dispute that they should not have taken.
But afterwards, in August?
Yes, on August 6th, again, there was a second meeting, and they brought a correct check with respect to the security and with respect to, I believe, the 1 month's rent, but they did not have a correct check for the broker. They had a personal check that was only for half the amount that was due to the broker, which was a breach of the lease terms. And additionally, they presented an insurance, supposedly proof of insurance, but that quote-unquote proof showed that they didn't have adequate insurance. It was.
So is that why they didn't get the key that day?
That's why they didn't get the key that day, yes.
So the issue is, according to them, that you breached because you didn't give them possession of the apartment. And
Correct.
according to you is that they breached because they didn't have all of the things that they required to have.
Weren't they in substantial compliance?
Not with
Sufficient to get the keys?
Not with the insurance requirements, which were required to be complied with prior to possession.
So let's just talk about the insurance requirements a minute. The requirement was that there be $1 million worth of coverage, that the landlord, the owner of the apartment unit be named as the insured.
That's correct.
Did the insurance, it didn't reach $1 million, but did they name your clients as the insured?
No, Your Honor. The document that was provided to our client was for a substantially lesser amount of insurance, and it did not list the unit owners as the additionally insured.
So was that a deal breaker in the legal sense?
I believe so, Your Honor. And our client, at least to the extent of taking possession at that time, and our client continued to demand performance and sought to, that they didn't want to walk away from this deal. They just were insisting on compliance with the insurance terms. Thank you, Your Honor.
We'll hear from you later.
Good afternoon. May it please the court, Vincent Chirico for the respondent appellant, Annette Cedeno.
Counsel, could you just address the issue of the insurance? Was it a deal breaker, and if not, why not?
It was not.
If they were given the keys, how would the landlord ever get named on the insurance?
That potentially is an issue of fact there, because they should have had insurance by the time the key was tendered. I will concede that. However, that was not the basis for failing to give the key. At no time during either the August 1st conversation telephonically or August 6th telephonic conversation, because the defendant appellant never showed up. She had her insurance broker or her real estate broker handle it for her. But at neither phone call did they mention either the insurance or the broker fee. They said, you didn't give us the right checks. Pursuant to our agreement, we're not giving you the keys.
So when you're talking about the right checks, you're not really talking so much about the broker's check. You're talking more about the what was going to be the security deposit, but then became in the proposed tenant's view, which should be the prepaid rent for 1 year instead of a security deposit for 1 year. Was that the deal breaker?
That was the deal breaker, and it goes to the very heart of our contention that there was never any meeting of the minds to begin with on this contract, because Ms. Cedeno.
So I asked the wrong question to him. That question was for you. Okay. So I'm sorry about that. That question was for you. I recognize that there's no question that a very vital term was changed in the new subsequent lease.
Yes,
Okay?
and
There's no question about that. But did you not ratify it by coming forward with the proper checks? Right? The 2 checks that they said, without these 2 checks, you're not closing. And then you came to the table with those checks, with not a complete check for the broker and a questionable insurance situation. But you attempted. Every single thing, all of those things were your client's way of ratifying the new agreement.
I would go one step further. On August 1st.
Is that a yes?
Yes.
Okay.
Yes. On August 1st, Ms. Cedeno shows up with the exact checks in the exact denominations as per the agreement that she signed, the original agreement before it was unilaterally altered in those material terms.
We don't have a copy of that.
I'm talking about the second.
We do. The original.
We have an unsigned copy of the first one.
Well, that's because she signed it and sent it on, but we have a copy of it.
No, but in the record, we don't have one.
We don't have a signature on the original lease, sublease.
Sublease, yeah.
Okay, but at 402 to 414, we have the exact initial lease that she testifies she signed, and the text
I know you want to keep going back to that, but I need you to focus on what I am talking about, which is once they have now, it falls through the first time, says, nope, those checks are not good, they're not written for the right things, no deal. They set a new date, and then she comes forward with the checks the right way. Why is that not a ratification?
It is, Your Honor, it is, and even...
So why are we here then?
Well,
Tell me.
We're here because she never got the keys. And there was never an agreement, even if there was an agreement by ratification on August 6th, when she does show up with the checks in the exact way that they asked for them, they still don't give her the keys because, and this is in the record, they say you have to strike out the word security deposit from the memo portion of the check. And she says, but this is what you asked me to do. And they said, nope, we're not giving you the keys unless you strike out security deposit on a $186,000 security deposit. Where in New York City on a residential lease do you take a $186,000 security deposit and then request that you pay $186,000 monthly?
Wasn't there an issue as to what her financial
Yes.
ability was, and the question of the condo board approval?
Right.
Wasn't that the big issue? Didn't she have like a zero income?
She had not enough income to justify the monthly rent amount. So the original deal, and this is why this is what the record evidence and the texts go back and forth. Hey, the purpose of this was to pay a year of rent upfront from which you would deduct every month the monthly amount, just to make sure that the co-op board was comfortable and approved this deal. That was the purpose of the $186,000. Despite that, to Your Honor's question, the ratification by them came on August 6th when they said, okay, I'll do it. I really want the apartment. I'll do it. I'll pay the extra rent. No, you have to strike out the memo of the deal. There's no discussion of insurance. There's no discussion of a broker's fee. We're not giving you the keys because we don't want you to say security deposit, but we want it to be a security deposit, $186,000.
Thank you.
Thank you.
You got 2 minutes.
Thank you, Your Honor. First, with respect to the notion that there was never any demand for insurance information following the initial issues with the checks, the tenant showed up at the...
Can we focus on the last thing he just said? Is Your friend claims that the basis for not giving the keys was not the insurance, but that she would not cross out the memo on the $186,000 check. Can you address that?
That's certainly his client's contention, and that is not our client's contention, but with respect to the specifics.
So she was never asked to remove that statement on the memo?
The deposition testimony, frankly, is a bit unclear from the broker who was present at the time. So there may be an issue of fact there, but it's not material here because there was no compliance with the insurance provision, which was, again, a prerequisite to taking possession, as my colleague conceded effectively. And again, the fact that she showed up with an insurance...
Well, he said you didn't care about the insurance because it wasn't mentioned at the time when she was there to pick up her key.
Respectfully, Your Honor, that's not the case because she showed up with the quote-unquote proof of insurance on August 6th, which was clearly in response to our client's demand for that. She wouldn't just show up for no reason.
I'm talking about on the 6th.
Yes, on the 6th, she showed up with that proof of insurance, which was non-compliant. So there's no her claim that she didn't know that she was supposed to be coming with proof of insurance at that time is clearly not the case.
That's not what I said, but okay. All right.
So on July 28th, there had been an email to her counsel setting forth the various requirements that she was to comply with prior to possession, and that included insurance, it included all the checks. So the claim that our client didn't reject on the basis of the failure to provide insurance is just not substantiated by the record.
Thank you.
Thank you, Your Honor.
And you have 2 minutes.
Thank you, Your Honor. My colleague, I believe, concedes that the broker's deposition testimony is unclear. What is clear is Ms. Cedeno's what is clear is Ms. Cedeno's testimony, where on page 113 and 114 of the record, she says, all right, I wrote exactly how they said it, and Ms. Khan, the broker, again telephones Appellant Baliki, who again refused to accept the checks unless Ms. Cedeno crossed out the word security deposit, page 113, 114 of the record. I would submit that the insurance was never a part of that conversation, and it was not a substantial part of the consideration in providing the lease. That's all in all. That's a secondary point. What we have here is an economic duress contention, because not only is she forced to pay $186,000 in security deposit, but then she's also asked to pay it again in rent. And then, oh, by the way, give us an extra $15,000. So she's being asked to give $370,000 when, for this apartment costing $15,000 a month, admittedly. There's no other questions?
Thank you.
Thank you, Your Honor.
Thank you both. And last but not least, Lopez versus ESH family.
Good afternoon, Your Honor. My name is Paul Golden. I represent ESH Family. Looks like I lost my audience, but anyway.
Don't take it personal. They have to get back in time to catch the cafeteria.
Got it. We've got 2 issues here. I'm going to try to fly through this as quickly as I can. Let me first focus on Gene Starr and the lease. We've got 2 clauses requiring the tenant to maintain and repair the sidewalk and fix its broken nature. One of them is in paragraph 30, which my adversary had indicated in his papers that the language in paragraph 30 pursuant to colado was indeed the kind of language that's required in order to indicate that the tenant does have the obligation to take care to repair and maintain the sidewalk. It's not just paragraph 30. We also have paragraph 67, which indicates that tenant at its sole cost and expense shall repair and maintain the sidewalk.
So are you arguing that while certainly that provision relates to the relationship between the landlord and the tenant, correct? But it doesn't absolve the landlord of his non-delegable duty as an owner to take care of the premises, and so that an action by a plaintiff is not impacted by your contractual arrangement with your tenant.
What you said is correct. That wasn't the point of our opposition. The or our papers was not trying to say.
I was just clarifying that, that's all. I'm not attacking you. It doesn't matter what I say, I'm always attacking. Go ahead.
I won't say what your reputation is, but sometimes it feels that way, so I appreciate that you told me that.
Yes, no.
I know you take both sides of everything, so I appreciate that. But in any event, no, that wasn't our position. Below was, hey, we're the owner, we don't have to,
Right.
we're not obligated to take care of the plaintiff. Not at all. It was simply that the tenant had these obligations under these. I've heard no, shall I say, legitimate or persuasive arguments from my adversary indicating, well, when it says repairs and replacements, or when it says repair and maintain, what that really means is sweeping off the dirt. It just doesn't make any sense in this context. Briefly, and then I'll move on to the other topic. My adversary uploaded a letter yesterday concerning a case called Carson. I've got a few comments on Carson. I had the chance to address it in my papers for obvious reasons. One of those is that in that case, it was the slope that was the issue. It wasn't that the concrete was broken, I'm sorry, that the cement was broken or anything along those lines. In that context, this court might say, well, listen, that is actually the landlord's obligation to make sure it's not sloped in the wrong way, as opposed to this, which just is plain old a broken sidewalk. And also we have an extra clause in this case which does not appear in the Carson case, which is paragraph 67, which, as I said, says the tenant at its sole cost and expense shall repair and maintain the sidewalk. I think I'm going to move off of this because it doesn't seem like I'm getting questions about it. So I'm going to move on to the Vista issue.
Okay.
Let me put it this way. Any New Yorker who's ever eaten pizza or who's ever had kids will understand that it's not your obligation to constantly be looking at the sidewalk, and things can get confusing. It's certainly understandable. So the plaintiff indicated she was just simply not clear where she fell. She did indicate that she fell before the jeans store at one point. If that's true, that means it was on Vista's property. She also said she was walking along and then felt something go below her. If you look at the pictures, you will see that before the area goes below, it first goes below when we get to Vista's property. She also indicated that it was between the properties. She also indicated that it may possibly have even taken place outside the circle she drew. Also, even within the circle she drew, it appears that that circle does include part of Vista's property. So all in all, this issue has to be left up to a jury to determine where exactly did she fall. I believe those were the majority of my issues, Your Honors. If you don't have any questions.
We'll repair the crack after the accident.
After the accident, that was our people. And of course, I don't need to explain, but you know, this is generally speaking, the courts don't take any effect or imply anything from that, because otherwise people wouldn't fix things, because they'd say, let it happen and let people fall. I don't want to be caught. But one of the issues in this case, of course, is that the court moved on, with great respect to the judge, the court moved on to parole evidence before first deciding whether there was any ambiguity. Our position, of course, is there is no ambiguity. It was absolutely positively the tenant's obligation to cure the sidewalk issues and should not have moved on to parole evidence.
You'll
Thank you
have
so
time on
much.
rebuttal.
Good afternoon, Your Honors. My name is Ronnie Solomon with the Adam Polo Law Office. May it please the court. We represent the plaintiff appellant, Ms. Robles Lopez. I'm just going to make one point. Mr. Golden made all of the points that we have put in our papers, but there's nothing in the record that states where this defect started. Did it start on Vista's property? Did it start on ESH's property and move to the other property? It doesn't, there's nothing in the record that states that it started in the middle and it expanded outward. The determination as to exactly where Ms. Robles Lopez did trip should be determined by a trier of fact, the
But
jury.
we already have an EBT, right? And we should be able to rely on what she says in that EBT, no?
That's correct. And
Okay,
Mr.
and she's very clear that while she's not seeing in front of her because of the pizza boxes, she can see peripherally which stores she's passing and which ones she hadn't gotten to yet, right?
That's correct. And she does state that she tripped in between the two properties. As Mr. Golden stated, she drew that circle as to where she tripped, and that encompassed both properties. Our position is that both properties are responsible for that defect. Neither one of them had repaired it prior to, and if they had, this of course would not have happened. It's our position that the responsibility is both on ESH and Vista Land because that defect is in front of both properties. So, thank you.
Good afternoon. May it please the court, Eileen Kaplan, Callahan and Fusco for defendant respondent Vista. Following up on what presiding justice has indicated, we have very clear.
Jurist presiding, I'm not taking Judge Renwick's job. I'm not the PJ, I'm the JP, but go ahead, I appreciate you, go ahead.
Apologize. You're demoted now.
Yes.
We have very clear deposition testimony from the plaintiff. She's walking, flat surface. The first time she encounters a dip is right before she falls. And she maintains that position under pressure from questioning counsel. She says, I know where I fell. It was lower, it was wide, like a wide step. It seems they want to hang their whole appeal on this question and answer. Is it possible? Is it possible you stepped in the condition that's not circled? Objection for conjecture. Okay, I don't know legal terms, possibly. It's possible I went outside the circle. Frankly, it doesn't matter if it was outside the circle because we have the elephant in the room, as one of the justices mentioned. We have the city's rule 2.07 that someone who owns and uses cellar doors has a non-delegable duty to
But there's no evidence that they use the cellar doors. What evidence is there in the record that those cellar doors were utilized?
They own the cellar.
By the tenant of?
No, I'm saying ESH, my adjacent owner.
Oh, okay.
Owned, occupied. I'm going against ESH.
Right.
Yeah, it's unrebutted. They used it, they owned it, it was locked. We have the city rule, non-delegable duty for them.
Your friends on the other side say that the circle encompasses your property and therefore you should be in. Why are they wrong?
She said it was in between. What I would say.
In between what?
In between both. This is her anecdotal testimony. She says that's what they're relying upon.
But is the circle in between? Does the circle in the photograph that she marks to say this is the area where I fell, is that circle in between both buildings?
Well, I would argue based on based on the testimony and our surveyor, we had a surveyor and his affidavit, and he said that the defect, which is the only defect which is consistent with the totality of her testimony, the so to speak hugging the cellar door, is on ESH's property. They haven't rebutted that. In addition, there's testimony that from Mr. Shoshani, who's the principal of ESH, that, oh, well, our property, you can see it clearly on the photograph 1656 in the record. Oh, our property goes up to the lock. I don't know how to describe it. The lock on our gate. And I would say if you look on the photograph that everyone is pointing to, which is in 645 in the record, that even the circle is on their side of the lock. But what I would like to focus, and they don't have any survey or anything, rebutting us on that location. But I'd like to turn, let's say it's outside the circle. Assuming for the sake of argument, they're gonna get the best construction of the evidence. It's outside the circle, I don't know legal. Respectfully, I believe Vista still was entitled to prevail. They have a non-delegable duty under 2.07. They haven't come up with any responding argument as to when there's a contest. Let's say Vista does have potential liability under 7-210. Let's say we do. It falls away when there's a contest between 7-210 and 2.07. That's what this court said in Storper, and Lewis and the Second Department said in Bob's Discount and the Flynn case.
Thank you.
Yep.
Thank you so much. We'll take a look at those.
Thank you.
You're here for?
For Gene Star, Your Honor. May it please the court, Dean Pereira for respondent Gene Star. I'd like to start with the plaintiff's claim, and then I'll go on to ESH if that's fine with the court. Sure. The only argument that I see plaintiff making in the brief is that we entirely displaced ESH's obligation under 7-210. So Justices Gonzalez and Mendez said in Alfani, which we cite throughout our brief, that, quote, to determine whether displacement occurred, the lease must be viewed in the context of the party's actual course of conduct. That's what the lower court was relying on. That's not parole evidence. That's what this court said. So what is the actual course of conduct? It's that the only one to ever do work on the sidewalk, structural work, is ESH. My friends on the other side say, oh, well, that was a subsequent remedial measure. But we're not, it's not being admitted for purposes of liability. It's being admitted for purposes of maintenance and control. So just based on that, we don't even really have to get into the contract to see the correctness of the dismissal of plaintiff's claim against my client. If I turn to ESH's contractual indemnification cross-claim, which is the only cross-claim that they discuss in their brief, okay? I'll get to the contract, but again, it's not only the contract, it's the surrounding facts and circumstances as well. And I cite the Drezwinski case from the Court of Appeals, where the court—
That's good. Let's get back to the contract.
Okay,
Because
so—
I started there. Right?
Yes, so we have paragraph 4 of the contract, okay? My adversary below primarily relied upon paragraph 67, which says tenant at its sole cost and expense shall repair and maintain the sidewalk. That has to be read in conjunction with paragraph 4, I argue in the brief, which defines the word repairs. It says tenant shall make all non-structural repairs. So when you read 67 and 4 together, okay, it's clearly 67 is talking about all non-structural repairs. Now, my adversary cites for the first time in the reply paragraph 30. There was never, ever, once ever any argument made with respect to paragraph 30 until ESH's and plaintiff's reply. But even if the court considers that, okay, I sent the court a post-submissions letter regarding the Carson case. I sent it yesterday. The exact same arguments were made regarding the Collado case, regarding paragraph 30 and paragraph 4. The exact same arguments were made, and the court rejected it. Another thing that makes Collado distinguishable with respect to the indemnification question is, again, this court has said that the most persuasive evidence of the agreed intention of the parties is the party's actual course of conduct. The court said that in Warburg. So here we have, again, the surrounding facts and circumstances, which we also look to for purposes of contractual indemnification, are ESH is the only one that has ever done anything on this record, made any sort.
You're basically arguing, since ESH had the good sense to fix what could cause somebody else to trip and create yet another lawsuit, that somehow equals they're responsible, they're negligent, and notwithstanding the contractual language in your lease, that you get a freebie. That seems to be your argument.
No, my argument is that we have to look at the surrounding circumstances as well as the contract, okay? Which I do argue that the contract is in our favor, okay? But if we look at the surrounding facts and circumstances, which we have to look at, they're making.
What evidence in the record is there that this was a structural defect?
I cite in my brief.
No. What evidence is there in the record? Do I have an expert from you saying that the repair was a structural repair and therefore under the contract he's responsible? Do I have that in this record? I don't remember seeing it, but maybe I missed it.
No, Your Honor does not. But I don't think there's any dispute that this is a cracked sidewalk. I think that's how it's been described.
A cracked sidewalk doesn't equal a structural defect necessarily.
I have a case that I cite in the brief where the court did say that a cracked sidewalk is a structural defect.
Oh, nice.
It's in one of the footnotes. It's
In the footnote? That's called dicta.
So, okay, it's 3650 White Plains Corp. versus Mama G, 205 AD 3rd 468, First Department 2022. The court said, quote.
I'm sorry, AD 3rd what?
468.
468 at page 470. Okay, the court described the defect as a effective raised cracked sidewalk, and it said it constituted a structural defect for which the landlord alone was responsible.
Okay.
So in summation.
I don't know what that crack looked like in that case, so not all cracks are structural defects, notwithstanding what that said. Okay? But go ahead.
So in summation, with respect to plaintiff, we didn't entirely displace ESH's obligation, so that claim was correctly dismissed against my client. With respect to ESH, we have to read 67 and 4 together, and we also have the surrounding facts and circumstances. So based on that, the court correctly dismissed plaintiff's claims and ESH's cross claims against my client. The court should affirm.
Thank you.
Thank you, Your Honor.
You have 2 minutes.
I'll do my best to fit within there, Your Honor.
No, you're going to.
Can my time start now?
2 minutes, go.
With respect to paragraph 30, my adversary simply didn't address that. Paragraph 30 was upheld by this court in Collado as meaning absolutely that the tenant has that kind of language, which is kind of foreign language, as you'll see in many contracts. This court said that means the tenant must fix up the sidewalk. And it's in his brief, it's on page 29 of his brief, where he admits that if that kind of language does in fact have that meaning. With my other adversary, primarily her arguments concern when the defect that the person has fallen on is within 12 inches of the sidewalk vault. There's no evidence that that's what happened here.
Look, I gotta tell you, this argument based on, yeah, possibly, maybe it's outside the circle, that's really not real convincing.
Leave that to the side then.
Not real convincing.
Please forget it. within the circle that she drew, includes Vista's property. We don't have to say possible.
But
We don't have to include
what,
that. Forget it.
what evidence is there of that, seeing as I have a surveyor and I have no evidence contesting that surveyor's findings? You're asking me from a photograph to discern property lines? That's what experts are for. It's called go to the buildings department and get what you need to get to prove that it's on both properties. You didn't do that.
I'll address that directly. First of all, if you make an extreme blow up of what the expert drew.
We are not gonna do an extreme blow up, right? We are deciding this case based on the evidence in the record.
It's in the record.
So you want us to blow up what's in your record?
No, it's his own report. It's his own report where he makes the circle, and part of the circle is outside the line, and that's one issue.
Is the
Second of all-
defect outside of in the property line? That's the important
The
thing.
defect is outside the property line. No one has disputed that. The defect is there, outside the property line. She said
Outside of her property line, in your property line.
part of it's in both. Part of it's in both.
Well, again, all I have is an expert who says that it's not.
And the
And,
expert,
and in controversy, to controvert that, all I have is, what, an attorney telling me, look at the photograph, it clearly is on both?
no one's disputing it's on both. It's what
They are disputing it's on both.
They are not disputing that. What they're saying is that the expert report shows the circle the way that expert drew it, but they don't say that circle matches up with what is actually on the photograph. If you look at the photograph, the way she drew it, and the way that the expert drew it, it's like Sharpie Gate from a few years ago. What he drew is totally unlike what's in that photograph. But in any event, her photograph encapsulated both properties. And she said, I was walking on flat ground.
Thank you.
You got it.
Have a good.
Thank you.